Hello, welcome to this episode on reductions in force and collective bargaining right rollbacks. There are two recent federal court rulings that have addressed executive orders in this area, which pertain to efforts on the part of President Trump to reduce the size of government through reductions in force and to remove labor protections under the Federal Service Labor Management Relations Statute. Ultimately, these disputes over these executive orders are going to have to be resolved by the U.S. Supreme Court. They are working their way through the federal court system now. On February the 11th, 2025, the President issued Executive Order 14210, which required that agency heads promptly undertake preparations to initiate large-scale reductions in force. The American Federation of Government Employees, which represents the largest number of federal workers, filed suit to restrain this executive order or its implementation, and a Northern District Court of California agreed with this request and issued a temporary restraining order, and also required the Office of Management and Budget and the Office of Personnel Management to provide the court with information about the details of reduction in force plans that were underway. The Trump administration, it has been reported, is complying with this order, but is still proceeding to look for ways to continue reducing the federal workforce. And also, the plans for reduction in force are undoubtedly proceeding within the agencies and will eventually be implemented if the green light is given by the U.S. Supreme Court. On March the 27th, 2025, President Trump issued Executive Order 14251 to exclude federal agencies from protection of the Federal Service Labor Management Relations Statute on grounds of national security. More than 1 million federal employees lost their collective bargaining and union recognition rights under this order, which affected agencies involved in national defense, border security, foreign relations, energy security, pandemic preparedness, cybersecurity, economic defense, and public safety. The National Treasury Employees Union represents certain employees affected in agencies under this order and asked for a restraining order. A U.S. Court of Appeals, D.C. Circuit, on May 16, 2025, granted the restraining order, and this court will have its decision undoubtedly appealed to the U.S. Supreme Court. The District Court of the District of Columbia on April the 25th, 2025 had issued an order which the appellate court heard and upheld that stipulated what is provided in this slide about the restraining order limiting presidential authority in this regard until further review. This is a little information about myself. I hope you've enjoyed this presentation. Stay tuned for more. Watch these cases closely as they will ultimately work their way to the Supreme Court and decide the extent to which the president has executive powers to undertake reduction in force plans and to rescind collective bargaining rights among federal employees on grounds of national security under existing statute. Thank you and have a good day.